Let's bring in Martin Radner. He's a Michigan-based attorney known as Brother Counsel on YouTube, a friend of this program, if I can say that. He's covering the trial on his channel again. So, Martin, let's start with the cross-examination of Trooper Nicholas Guarino. Do you think the defense was able to accomplish what was clearly its goal, to poke holes in that damning evidence around the Google searches? Did they score any points there?
Oh, yeah. Well, when you have bad facts, when you have these Google searches which look really incriminating, what you got to do, if you're the defense attorney, is you got to figure out a way to show the jury why those searches don't hurt you, how you're trying to show that these searches may actually help your case. So you don't try to just ignore it and take the focus off of the Google searches. You try to focus the jury's attention on the searches that help you. For example, the fact that murder didn't appear in the searches initially. He initially was just talking about how to dismember a body, which again is incriminating, but they're not disputing that fact that Brian Walshe did that. They're disputing the fact that he murdered Anna Walshe. So if you can try to focus the jury on what helps you a part of the Google searches, then that's going to help you. So for example, searching for Porsches, searching for a 4-carat diamond. Who's going to do those type of searches for their wife if they're planning on either divorcing them or murdering them?
So speaking of cross-examinations more broadly, we haven't seen that much attention paid to that part of the case by the defense, unlike, of course, the Karen Reed trials, which we were all watching together. Every witness seemed to be cross-examined, and some for multiple days. Is the defense leaving opportunities on the field here by not cross-examining more often?
Well, it could be that the witnesses in this case are just being more honest and truthful.
Okay, well, no, I see what you did there. Okay.
But no, I mean, the point is that when you have a tough case like this, when you have the facts that are unhelpful and which you've already admitted to some of the incriminating things in this case, so the one you got to focus your cross-examination on is just sometimes short points that can help your case. If you try to go down the rabbit hole, you try to open up all the different areas and avenues, then it can really backfire. So what I'm seeing from the defense in this case so far is that they know their theory of the case, which again is tenuous, but they're trying to work with it and trying to just ask pointed questions that will help them to achieve their theory and to prove their theory to the jury. So therefore, it makes a lot of sense to me that they don't want to cross-examine too much. They don't want to open up all these different areas where things can look a lot worse for them and incriminating for Brian. And sometimes the best way to cross-examine is to not ask any questions at all. Some elementary trial lawyers in the beginning, they'll think that if it's cross-examination, you got to ask something. And that's not always true. Sometimes if a fact is not going to hurt you or you're not disputing it, then just say no questions. And that seems to be the approach that these seasoned, experienced attorneys are taking.
And Martin, the lack of cross today meant that we got through nearly a dozen witnesses very quickly. The pace of this trial is moving so fast. And I wanted to ask you about what seems to be a lack of disagreement between the prosecutors and the defense here. We have a graphic that we've been showing to people at home so that they can follow along. Of course, in the Reed case, almost everything was fought over. We've just discussed that, especially because in some cases we didn't think that the witnesses were being truthful. But with so much agreement here, except on the one issue about how Anna Walshe died, is this simplified sort of Venn diagram that you're looking at favored the defense or the prosecution?
Well, I mean, you can argue that it can favor the prosecution and the defense because, a lot of the issues here that Brian Walshe was lying about the fact that she went missing. The defense agrees with that fact. Now, the prosecution is going to argue well, that helps their case because it shows that he's trying to hide a murder. But according to the defense, they're going to say, well, he was lying because he was panicked and he had nothing to do with the murder. This was just a sudden, unexplained death. So a lot of the witnesses that we're seeing so far is establishing a lot of the facts that the defense is not really going to push back so much on because they think, look, we're not going to fight the disinterment of a body. He already pled to that. We're not going to fight the fact that he lied to the police. He already pled to that. So if it doesn't have directly to do with him committing the murder, we're just going to leave it alone, and we're going to allow them to show their investigation about the missing person and show them that Brian Walshe lied. The defense is going to say, we agreed with that. again, if that's going to actually help them ultimately get an acquittal, I don't see that really working out at this point. But that is their theory, so that's what they're stuck with, and that's their approach to this trial. So you're not going to be finding them fighting on every little detail about the investigation, about the missing person investigation, about the all the items that they found in the trash and in the dumpsters, and that he did disinter her, he did dismember her. So they're not going to fight that. So they're just kind of letting it go and letting the trial play out.
All right, Martin Radner, brother counsel, thanks very much for your counsel tonight. We appreciate it. Hope to see you back on the show before this trial is over.
Me too. Nice to see you again also, Glenn. Thanks for having me on.